When last we left the Kyle Rittenhouse story, the prosecution had taken a series of losses at a pretrial evidentiary hearing. They wanted to include evidence that Kyle was involved in a June 2020 fight between his sister and another woman. They wanted to include evidence that Kyle is a Proud Boy and made Proud Boy hand gestures, but both pieces of evidence were tossed and will not be considered at trial. The prosecution also wants to include evidence of Kyle saying he wished he had his rifle to deal with other looters on a different day prior. That video remains a possibility for inclusion at trial, though the judge says he leans against it. It's a possible indicator that the prosecution is really grasping at straws to build their case. Now, sure, you'll take everything you can strategically to win, but if these are just weak pieces of side support that may be beneficial to the state if they can get them, then why were the prosecutors visibly frustrated as though they were losing key evidence? It's not that big of a deal if the jury won't hear your 10th strongest argument. But it is a big deal if the jury won't hear your first, second, or third strongest arguments. And if Kyle throwing up the OK hand sign months after the incident is among your strongest arguments, your argument isn't strong. But of course, we don't know. One bad pretrial hearing for the prosecution doesn't mean that the trial overall will be bad for the prosecution. But how about two? Because there was another pretrial hearing on Tuesday, and it was another day that did not fare well for prosecutors, not just because of testimony that built a solid case for the defense, but because the prosecutors didn't have solid arguments against it, either on the substance of the testimony itself or whether that testimony should be included at trial. This is the testimony and analysis of John Black, a use of force expert with a doctorate in cognitive science, 23 years police training experience, 30 years special forces experience, certification in firearms instruction, and a man who has consulted in use of force legal cases 60 plus times. He's written opinions in 32 of those cases, and he's testified in 20. And he's prepared a report on his analysis of the Rittenhouse case for the defense. That report concludes that Kyle Rittenhouse acted reasonably and in compliance with Wisconsin self-defense laws throughout that night. And the defense team is now making the case to the judge to allow Black to testify before the jury at trial. And while Black's testimony isn't necessarily anything new for people who have followed this case closely and evaluated the video evidence, it is confirmation of two things. Number one, that a man with decades of professional experience investigating and analyzing evidence in events like this one sees this case in much the same way that many of the internet hobby analysts do. So there's substantiation and support for a lot of the analysis already done. And number two, that this professional investigation and analysis doesn't appear to have uncovered any major new information or evidence that the internet analysts hadn't already found. That means it is less likely that the prosecutors have any major surprises up their sleeves. Black's analysis breaks the incident down into two parts. The first part at the gas station, in which Joseph Rosenbaum chased and cornered Kyle, throwing objects at him. In that situation, Black says that Kyle is clearly retreating and Rosenbaum is clearly the aggressor.
He is moving away from somebody to be pursued. There's an object being thrown at him, which means he is the defender or he is in a reactionary mode.
The acting force in event number one, would that be Mr. Rosenbaum?
I would think it would be absolutely expected or reasonable that that would be the causal action, because up until that point, he was not moving in that area.
And because Rosenbaum reached for Kyle's gun, it was a reasonable belief for Kyle that Rosenbaum was attempting to inflict serious bodily injury.
Would it be reasonable for a person to want to retain their firearm from another person who has threatened to kill them in the past?
Yes.
Why?
Because if their firearm is taken away from them, and if they believe that person to be willing to do them serious bodily harm or anything else, a reasonable perception would be once they take that firearm, they're going to potentially use it against me.
In the second part of the incident, Kyle's further retreat and the subsequent attacks in the street, Black concludes the same, that acts of serious bodily injury were repeatedly inflicted aggressively toward Kyle, starting with jump kicker guy.
Being kicked to the head can cause severe damage, serious physical injury, and is a potential to cause death, yes.
And then skateboard guy, who not only hit Kyle with a weapon, but also attempted to take his rifle.
If that hand is down there, that hand is potentially going for the weapon. If Kyle Rittenhouse had perceived that, would I say that that's a reasonable perception? Yes.
And then you have the comrade with the missing biceps, who of course bluff surrendered and then pointed a gun at Kyle.
As he gets shot from the first position with his hands up to when he shot in the arm. Is he moving away from Kyle Rittenhouse or moving towards Kyle Rittenhouse?
I would argue that the evidence shows that he is moving towards.
It's Black's opinion that Kyle's actions weren't just in compliance with use of force norms in his professional expertise, but specifically in compliance with Wisconsin laws on defensive use of force, which allow it when the actor, Kyle in this case, reasonably believes that such force is necessary to prevent imminent death or great bodily harm.
You've reviewed this for whether or not Kyle's actions were reasonable under the self-defense law of Wisconsin?
That's correct, under the Wisconsin statute.
And do you have an opinion as to that to a reasonable degree of scientific certainty?
I believe the actions comport with it.
And the prosecution's response to the defense's effort to get Black to testify at trial was a total mess of inconsistency. First, they said that no expert testimony is necessary or even valuable because only the jury will judge reasonableness, and all of the jurors will be perfectly reasonable themselves.
The state's position is that the jury does not need to hear from an expert to make a decision on the issue of self-defense here. The jury instructions are quite clear that it's what a reasonable person would feel is appropriate, and I think we'll have a jury of reasonable people.
Unless, of course, the jury hears from the wrong expert, in which case the jury suddenly becomes unreasonable and the experts become useful, and the jury needs to hear from our expert now.
We also retain our own expert, Bob Willis, as in the process of preparing his report. As I indicated to the court yesterday in my email, he should have it by October 18th.
The prosecution initially attacked John Black's personal qualifications rather than the substance of his analysis, implying that Black only has expertise on police use of force, not civilian.
Is it fair to say then that the times that you have been qualified as an expert witness relate to police use of force as opposed to civilian use of force?
I'd say the majority would be related to police use of force. That's correct.
As though the same fact patterns, principles, and general legal constraints don't apply to both. It's like arguing you have no relevant knowledge as a mechanic because you've only worked on Ford but not Chevy. Plus, it's not even accurate. John Black has done plenty of work on civilian cases.
Is it correct to say that in every single one of those cases, one of the parties is a law enforcement agency?
No. The short answer to your question, sir, is no. I'd have to go through them, but I have advised on self-defense cases before.
But that's not even close to the worst of it. The prosecution preposterously implied that the skateboard attack wasn't an attack because of the way the guy was holding it.
Would you agree with me that if indeed someone like Mr. Huber, hypothetically, had a skateboard and intended to use it to cause harm, they would hold it differently than what we see Mr. Huber holding it in this video, correct?
No, I would disagree with that. I haven't been trained in understanding how to use skateboards as a weapon, so I don't have a reference point. I can tell you how to use bats and other things as a weapon.
Now that's an argument I really hope makes it to trial. It's only assault depending on the grip of the weapon. If you hold a baseball bat upside down, you can take free shots at someone's face because that's not the best way to do damage. The prosecution heavily focused on Kyle's possession of the gun, since Black had said that repeated attempts at grabbing Kyle's gun were part of his conclusion that Kyle had acted reasonably in defending himself from that aggression. And so the prosecution asked in the case of each shoot if Kyle would have been justified in using deadly force if he was not carrying that gun. And Black said he may not have been in certain situations.
If everything else in the situation was the same, except Mr. Rittenhouse did not have that gun, is it your opinion that Mr. Rittenhouse would have been reasonable and justified to use deadly force against Joseph Rosenbaum?
Given all the other facts as seen, there wasn't any other big fighting or kick to the head, I would argue no.
Correct.
It wouldn't be a reasonable response.
If all of those circumstances regarding Anthony Huber and Mr. Rittenhouse are exactly the same, but Mr. Rittenhouse does not have a gun, would you agree with me that it would not have been reasonable for Mr. Rittenhouse to use deadly force?
It's a hard hypothetical for me to fathom.
Number one, you'll notice the prosecution doesn't apply this hypothetical to Missing Biceps Man. Why? Because that guy pointed a gun of his own at Kyle. Number two, counterfactuals are not what we're judging. We are judging what actually happened. Hey, if Skateboard Man had just skated by and minded his own business instead, but Kyle still shot him, would that have been justified? No, it wouldn't have been. Also, that's not what happened, so it's not really relevant, is it? But number three, it's just a bad argument, legal or layman. I get the angle the prosecutors are trying to take. They're trying to say that it was Kyle who created the danger himself with his illegitimate possession and carrying of the rifle. That's why the first part of this hearing was dedicated to the interpretation of Wisconsin's hunting statutes. The defense believes those laws allow Kyle to possess and carry a firearm, an argument they made trying to get Kyle's weapons charge dropped. The judge denied that motion for now, but he does say the statutes are unclear and he needs further time to review them. And that was also the basis for blue check tweeters who spent under 5 minutes looking at the story to claim that this legal unclarity was actually the substance of the hearing. Kyle Rittenhouse says he was just hunting? Oh my God, what a stupid defense. What was he hunting? Black people? Ha! Got him! No. As demonstrated by the fact that no black people were shot or died, and the fact that Kyle was just hunting is neither the defense offered nor the substance of the hearing. That is a misunderstanding of a secondary point to a secondary argument that the prosecution is trying to emphasize. The actual strategy for the defense being if they can eliminate that gun charge, the crux of the prosecution's case falls apart. The prosecution is saying that because Kyle's gun possession is illegitimate, his claim to self-defense is illegitimate. So if the defense team can eliminate that claim for the prosecution's case is dead. And even beyond the legal technicalities, it's an argument that should lose, regardless of if the defense team's strategy succeeds. Because whether you legally possess property or not does not and should not dictate your right to defend yourself or not. Consider a hypothetical that actually aligns with the facts here. Let's take the gun emotion out of it. Let's say instead of a gun, Kyle had a car that night. And let's say that this car isn't street legal or Kyle's not licensed to drive, or there's some other legal reason why he's not supposed to be in possession of or operating this car, just like the gun. And let's say Kyle is watching that same riot in Kenosha that same night from inside of his car instead. And that same mob learns that Kyle's car is illegal. And they start beating on his car. And they start beating on him personally. And so in order to protect himself, Kyle has to drive away. And in the process of doing that, he hits and kills someone who had been attacking him. Is the argument in that case still, well, Kyle shouldn't have had that car. It wasn't street legal and he wasn't licensed to drive it. Therefore, he forfeits his right to defend himself. And now he's a murderer, even though he's the one who was attacked? Or is the proper conclusion that the people who attacked Kyle are not justified in their aggression, no matter what property he has in his possession? Consider it another way. It is a violation in many cities to skateboard on the sidewalk. That does not mean I get to approach a skateboarder and take his skateboard and beat his face in with it. And if I did, it wouldn't be a good argument to say, yeah, well, that's what he gets for skateboarding around here. If he wouldn't have brought that prohibited skateboard here in the first place, none of this would have happened. I'm still the aggressor in that situation. I have still committed assault and battery. The last piece of bad news for the prosecution is it sounds like the judge is inclined to include John Black's testimony at trial.
On the subject of expert witness, I'm going to use Dr. Black's report as an example because it's the only one I have. There are many points in there that I think are suitable for expert witness testimony. So I definitely think there's much of value in terms of that could be useful to the jury in reaching their verdict in the case.
And the judge also called out the prosecution for using their own use of force experts all the time, yet suddenly deciding now that they're useless.
Your office has been using use of force experts. You used it in the Jacob Blake Shesky shooting. You used it in the shootings. There was an officer involved in a couple of shootings, and you used a use of force expert in that. Why would it be inappropriate for this kind of evidence to be utilized by the jury?
And even if John Black does testify at trial, it doesn't necessarily mean that it's a slam dunk for Rittenhouse's defense. We'll have to wait and see what the prosecution's self-described useless expert brings himself. And don't forget that the prosecution still claims to have FBI drone surveillance images that show Kyle Rittenhouse initiated the aggression that night. It's a claim I still find baffling for several reasons. It makes no sense for the prosecution to focus so heavily on these side issues if they can easily prove that this is not a self-defense case at all and that Kyle is the aggressor. It's a claim that contradicts witnesses and the prosecution themselves, who originally acknowledged that Rosenbaum followed Rittenhouse and attacked. not that Rittenhouse initiated attack. And now it's a claim that's totally unsupported by the thorough investigation and analysis of a man with decades of professional experience investigating and analyzing exactly this sort of situation. The prosecution is flailing at the sky while claiming to hold the silver bullet. Why? It's evidence that would totally change the case in their favor, but they spend none of their time on that and all of their time on this secondary nonsense. Why? They are taking losses leading up to the trial, and they haven't yet introduced potentially the only piece of evidence they need to win. Why? The only explanation that I can figure based on recent FBI and other federal agency behavior is that it's not ready to be shown yet, that maybe there are still a few upgrades and modifications that have to be made. But when it does come out, just remember that, hey guys, this definitely is not a lab creation, is not an explanation that's held up well to scrutiny lately. Thanks as always for listening and for supporting this channel. Always appreciate that thoughtful discussion down below, and especially over on Minds, that is at ML Christiansen. You're always welcome to coming out and chat in my live streams. Those are linked down in the description. Looking forward to it. Goodbye.